Hello, welcome everyone. So as folks keep trickling in, here I am. Great, thanks. So as folks are trickling in, thanks so much for joining us. I'm going to go ahead and start introducing our panel event tonight. I'm going to be setting the stage for our conversation, and then I will go ahead and introduce our fantastic speakers. My name is Liz Reiner-Platt. I'm the director of the Law, Rights, and Religion Project at Columbia Law School. And in case we're new to you, the Law, Rights, and Religion Project is a law and policy organization that promotes freedom of religion, religious pluralism, and social justice. We are based at Columbia's Center for Gender and Sexuality Law. And this whole center has a lot of really wonderful events that are happening this fall. So I do hope you'll check those out on our website. I believe Lilia will be dropping the link to that in the chat box. I also want to mention that our amazing partners at Auburn Seminary are actually hosting a conversation immediately after this one on how to talk about faith and abortion. So you can also get the link for that event in the chat. But today, of course, our panel is going to be focused on the intersection of abortion rights and religious liberty, and specifically the question of whether the right to religious freedom under US law does or should include a right to receive, perform, or facilitate access to abortion. Right now, we are seeing two parallel trends in US law and policy. So first, a sweeping expansion of the right to religious exemptions, that is the right of faith practitioners to be excused from compliance with laws that conflict with their religious beliefs or religious practices. In some cases, these religious exemptions can be derived from the US Constitution, and specifically the Free Exercise Clause of the First Amendment. In other cases, however, religious exemptions can be granted by specific state or federal religious exemption laws, the most notable and expansive of which are Religious Freedom Restoration Acts, or RFRAs, which provide a very robust right to religious exemptions from nearly any government policy or act. Both constitutional and statutory religious exemptions have been given a broader and broader interpretations by the Supreme Court in recent years. So most recently, the court vastly expanded the constitutional right to religious exemptions in a series of cases that exempted religious gatherings from compliance with state public health orders in the wake of the COVID-19 pandemic. At the same time, we're seeing states pass some of the most draconian restrictions on abortion ever. So of course, we all know in September, Texas's SB 8 became the first 6-week abortion ban to actually go into effect since Roe v. Wade, effectively overruling that decision for people in Texas. So the question we're going to be facing in this panel is, are these two trends, this vast expansion of the right to religious exemptions and total bans on abortion access, on a collision course? For actors who have long been invested in just conflating religiosity at large with opposition to abortion, religious liberty and abortion restrictions are not intentional. Quite the opposite. In a recent amicus brief to the Supreme Court in an upcoming case on abortion rights, the conservative religion law firm Beckett wrote that the law of religious liberty has been haunted by abortion. And essentially the underlying assumption of that brief is that allowing states to completely prohibit abortion would actually minimize rather than create burdens on religious liberty. This argument intentionally overlooks an incredible diversity of both institutional and individual religious beliefs about abortion. We know that many large and established denominations support the right to abortion in most or all circumstances. And some denominations have even stated that abortion access is essential to religious freedom. In 2011, an association of rabbis issued a resolution stating that to withhold abortion access from patients on religious grounds is to deprive them of their constitutional right to religious freedom. The Evangelical Lutheran Church has issued a statement that for some, the question of pregnancy and abortion is not a matter of governmental interference, but a matter of religious liberty. And even in religious denominations that adamantly oppose abortion rights, there are very significant minorities who believe that abortion should be legal in all or most cases. And according to the latest Pew data, that includes nearly half of Catholics, a third of evangelicals, and over a quarter of Mormons. Many abortion providers have described their work in religiously motivated terms. Dr. George Tiller, an observant Lutheran who was murdered at church by an anti-abortion activist, referred to his work as a ministry. Dr. Leroy Carhart, a Methodist, stated in an interview, I think what I'm doing is because of God, not in spite of God. And Dr. Sarah Immersheen, a Jewish abortion provider, has called providing abortion care a mitzvah or a good deed. So the idea that freedom of religion should include the right to access or to provide abortion shouldn't seem far-fetched to us. And in fact, it's not a new argument or belief. Abortion rights litigators made this argument years ago in cases challenging abortion restrictions like the Hyde Amendment, which bars the use of federal funds for most abortions. And in 1980, a federal district court judge actually ruled that the Hyde Amendment restricted religious freedom, holding that the liberty protected by the Fifth Amendment extends certainly to the individual decisions of religiously formed conscience to terminate a pregnancy for medical reasons. And that part of the opinion was later overturned by the Supreme Court, but only on procedural grounds. During the 90s, during the initial congressional debate over the passage of the Religious Freedom Restoration Act, the U.S. Catholic Conference and National Right to Life Committee were actually skeptical of the proposed bill, specifically because they feared that broad religious exemptions could be used to expand abortion rights should the anti-abortion movement succeed in overturning Roe. So, while a religion-based argument for abortion rights seems to have mostly fallen out of favor, like at least in the litigation front in recent years, there are some lawsuits that continue to make this argument. For example, the Satanic Temple has brought suits in Missouri and Texas, arguing that its members' religious beliefs, including a belief in bodily autonomy, are burdened by laws imposing mandatory waiting periods and other restrictions on abortion. And some of these suits have been dismissed on substantive or procedural grounds, but others are ongoing. So with that, let's hear from the folks you're all here for today, our speakers. I'm going to keep introductions very, very short so that we can dive right in and get to the meat of things. And we will drop the full bios in the chat. So first, we'll be hearing from Dr. Gillian Frank, a historian of sexuality and religion with a forthcoming book on the Clergy Consultation Service on abortion. Dr. Frank will be providing some historical background for us and context on the intersection of religion and abortion rights, including discussing some of the earliest legal claims on this issue. Next, we'll be hearing from Reverend Dr. Kerry Jackson, Director of Spiritual Care and Activism at the Religious Coalition for Reproductive Choice. Reverend Dr. Jackson will talk about the religious abortion rights movement today and the conversations that are happening among faith leaders about how to protect their religious liberty in the face of ever increasing restrictions on abortion. And then finally, we'll be hearing from Rupali Sharma, Senior Counsel and Director at the Lawyering Project. Ms. Sharma will speak about contemporary challenges to abortion restrictions based on religious liberty, where the law might be headed, as we imagine potentially a post-Roe world in the future. So our panelists are going to be speaking for 10 minutes each. We'll then have some time for a group discussion, and we will be concluding with a Q&A. So please go ahead and put your questions and who they're addressed to in the Zoom little Q&A button at the bottom. So thanks so much. And with that, I'll pass the mic to Dr. Frank.
Thank you so much. Good afternoon, everyone. It's such a pleasure to be with you today and to share some of the research from my book, A Sacred Choice, Liberal Religion and the Struggle for Reproductive Rights, which is forthcoming from UNC Press. So my book reveals a forgotten history of religious activists and their long struggle for reproductive freedom. And in it, I trace the evolution of a liberal religious theology of choice from the contraceptive battles of the 1930s to the abortion rights struggles of the post-war period. The centerpiece of my book is the Clergy Consultation Service on abortion, which was the largest abortion referral service in the United States before Roe v. Wade. This group was made up of over 2,000 liberal Protestant ministers, Jewish rabbis, dissident Catholic nuns and priests, and a laity from a spectrum of denominations. The CCS was also active in 40 states, 2 Canadian provinces, and in Tokyo, Japan between 1967 and 1973. During its brief existence, volunteers for the CCS counseled tens of thousands of abortion seekers, using the legal protection afforded by the priest-penitent relationships. They referred these women to pre-vetted, illegal, and legal abortion providers in an extensive international medical network. And CCS clergy did so publicly, while advancing an ecumenical theology that lifted up women's voices and advanced their reproductive choices. By 1973, when Roe v. Wade legalized abortion, CCS branches had already established their own abortion clinics and integrated their services with a number of healthcare groups, including Planned Parenthood, in order to continue offering holistic reproductive care. So I've been tasked today to highlight one aspect of the CCS story, which was the history of their liberal religious legal activism before Roe. The CCS's legal history, what we're billing today as a religious right to abortion, is something of a patchwork. It exists in a series of legal challenges that were mounted and dismissed on procedural or circumstantial grounds in cases like Lyons versus Lefkowitz of 1969 and Landreth v. Hopkins, 1971. We also find the theory behind their activism if we peek into amicus briefs, depositions, and circumambient statements in cases like Commonwealth versus Brunel and Commonwealth versus Hare, both from 1969 to roughly 72 and both in Massachusetts. And you can see the theory and the practice in the shadow of Doe v. Bolton, which we don't usually think of as steeped in liberal religion because of how it wound its way through the courts. Now, I'll dig into each of these cases momentarily. And if we had more time, I would also invite us to expand our gaze to clergy testimony given during legislative hearings on abortion. There, as in court filings, we find mainline Protestant and Jewish clergy articulating both denominational and ecumenical principles of a religious right to offer reproductive counseling, a religious right to make abortion referrals, and a religious right to access abortion. And I'll also dig into these three pillars of the CCS in a moment. But I want to place these theological ideas in context. And we need to understand that the CCS grew out of long-standing practices of clergy quietly helping abortion seekers obtain both legal and illegal abortions. This pastoral counseling placed clergy counselors and their congregants in quiet conflict with the laws governing abortion. By the early 1960s, as Jewish and Protestant denominations lined up to support abortion law reform and repeal, some activist clergy became impatient with the pace of change. There was a widespread sense that Catholic power would delay abortion reform indefinitely, even as the body count of illegal abortion seekers continued to mount. And it was against the dual backdrops of a public health crisis and Catholic legislative power that the CCS announced its intent to offer abortion counseling and referral in order to, in their words, dramatize our deep feelings for the necessity of the liberalization of the law. They sought to extend the sanctity, and this is their words again, the sanctity of the pastoral counseling relationship into the public square. The CCS, in other words, made the pastoral political by breaking laws that they proclaimed were immoral and simultaneously lending moral authority to abortion seekers and abortion providers. By building and maintaining an international network of safe and reliable abortion providers, and by offering counseling and referral, CCS counselors became vital links in an information chain that enabled thousands of abortion seekers to get much needed reproductive services. Legal restrictions in that era meant that many abortion seekers had difficulty finding answers to fundamental questions like, where can I obtain an abortion? How will I get there? Can I trust the provider? Can I afford the procedure? And what do I do if something goes wrong? And it was through these acts of pastoral counseling and information sharing, of helping women travel safely across state or national borders, and to navigate domestic and foreign legal and medical systems, that the CCS clergy came into contact and conflict with law enforcement and with legislators. And most of the time, authorities were willing to look the other way, if not outright assist clergy in their activities. But occasionally, CCS clergy found themselves in the crosshairs of crusading district attorneys and state politicians who sought to squelch their counseling and referral activities. One early incident involved Hyde in Chicago, who tried to depose CCS members. Now, the details of these clashes are worth mining, if only to see the religious and legal theories at play, and the ways in which anti-abortion activists exercised power. Now, one of the earliest reckonings of consequence took place in 1969, when an Ohio minister named Robert Hare ran afoul of Massachusetts laws that held that any person who aids, counsels, or procures another for abortion was subject to the same penalties as the person performing the surgery. Now, Hare was a Presbyterian minister and a member of the Cleveland CCS, and he had referred local women to a Massachusetts provider named Pierre Brunel. When Massachusetts police raided Brunel's home, they found, among other things, thank you notes from Cleveland area women whom he serviced. So the Massachusetts investigators traveled to Ohio. They badgered these women at their homes and at their workplaces, pressuring them to testify about the circumstances that led them to Brunel. And for one school teacher who was confronted at her workplace and threatened with exposure and potential job loss, the pressure was too much. She gave up Reverend Hare's name. And in a case that eventually ended up in the Massachusetts Supreme Court, the Commonwealth charged Hare with being an accessory to abortion before the fact. What's noteworthy about the case is where we see the articulation of a religious right to abortion. It's not in Hare's lawyers' arguments, which focused on jurisdictional and technical issues. Instead, we find them in the surrounding campaign of the Presbytery of Cleveland, which issued a statement asking that Massachusetts bring them up on charges, saying that they were corporately aware of and responsible for the alleged violation. The Presbytery affirmed that Reverend Hare was acting on, in their words, the basis of his ordination vows and the confessional position of this church. And commentators at the time asserted that it was the Presbytery's bold affirmation of abortion counseling and referral that helped shape a decision in Hare's favor at the Superior Court level. They believed in Voke and Griswold that the court was reticent to regard the confessional as less private than the bedroom. Now, Massachusetts DAs doggedly pursued a case against Hare for years, and the case was only dropped with the passage of Roe. In the companion case against the abortion provider Pierre Brunel, his lawyers brought religious freedom to the fore and challenged the abortion laws in Massachusetts on the grounds that the Commonwealth had adopted, in their words, legislatively the moral position of the Roman Catholic Church to the detriment of the positions of other denominations and also non-religious persons. A who's who of Protestant and Jewish clergy submitted affidavits elaborating upon the religious right to abortion. And the arguments hovered on three overlapping points that would be reiterated time and again by the CCS and others in their denominations in concurrent legislative debates. The first, restrictive abortion laws interfered with the free exercise of religious imperatives of clergy. Bishop Anson Phelps Stokes, the Episcopal Bishop of Massachusetts, put it this way: it prohibits Episcopal clergymen to deal with reproductive problems of congregants. Second, restrictive abortion laws violated the religious conscience of congregants. In the words of Rabbi Sanford Seltzer, who spoke in his capacity of director of the New England Council of the Union of American Hebrew Congregations, Reform Judaism believes that civil law on abortion to be much too stringent and completely antithetical to the individual's autonomy in sexual and family matters adhered to by Reform Jews, and that many women members of congregations that he has counseled are unduly restrained by the civil law. And third and finally, the clergy collectively attacked the metaphysics of immediate animation underpinning abortion restrictions, which held that the fetus was a child and that abortion was murder. The embryo, the product of fertilization, is not considered to be a human being, they said in multiple iterations. Now, this case, Brunel's case, was an imperfect platform for articulating religious rights to abortion. He was a profit-driven provider with questionable skills who had already lost his medical license, and the religious issues raised were largely overlooked at trial. But these three vectors, clergy rights to counsel and refer, the status of the fetus, and a woman's religious right to control her reproductive life, outlived the proceedings and became axiomatic in liberal religious arguments about abortion. Now, I'm going to conclude by just noting that it would be this first iteration, clergy's right to offer abortion counseling, that would be most expressed in subsequent legal cases before Roe. It came up in a New York case called Lyons v. Lefkowitz, where a member of the CCS sued for a constitutional right to refer his pastoral counselees to qualified gynecologists and surgeons. This case was mooted after New York legalized abortion. It was expressed in Landreth v. Hopkins in Florida, when two clergymen in the CCS tried to preempt a grand jury investigation and potential charges under Florida statutes, which prohibited advising, aiding, or assisting abortion seekers or circulating any material that gave any advice, direction, information, or knowledge. And the issue came up again in Georgia when Atlanta-based CCS ministers joined in Doe v. Bolton, arguing for a religious right to offer abortion counseling and referral. A judge found that the ministers lacked standing, even as it allowed others in the suit to proceed. So in these patchwork of cases that emanated around abortion counseling and referral, the claim that there was a religious right to share accurate information about how to obtain abortion services was never fully tested. The other prongs, a religious right to access abortion, and the theological underpinnings of laws constructing the fetus, were also never fully realized or dignified in jurisprudence and legal precedent before Roe. So in the shadow of SB 8, which attempts to choke off abortion access and information, it's unclear to me whether this history of faith-based abortion counseling and the attempts to legally enshrine it is a usable past as a model or a cautionary tale. But today, as abortion seekers travel across state lines, aided by people of faith, such ideas may, of necessity, move from the penumbras of past legal arguments to our present. Thank you for listening.
Thank you. I'm so honored to follow my friend Gil Franks, and I just feel so blessed by the work that Gil has done. And I want to talk very briefly about the context of serving as a minister in today's era and how to negotiate the kinds of conversations that are needed today. A lot has shifted in the religious and political landscape in the past 50 years since the Roe decision was handed down. And the three prongs that Gil just spoke about, counseling, abortion counseling, abortion access, and the determination of fetal life, those are three critical prongs. And in today's era, the kinds of shifts that have happened religiously and politically have created something very, very different in the landscape for us. I'm going to share something that I hope will be valuable for all of you. One is, in the past 30 years, there's been the development of something called Dominionism. It is a theocratic idea that regardless of any individual's theological or religious beliefs, that God has called a certain group of people, of Bible-based Christians, to exercise dominion over the society by taking control of political and cultural institutions. Now, I grew up in the Pentecostal Apostolic Church, a very small subset of Protestantism. And during the years I was growing up, I was told again and again and again, be in the world, but not of it. And essentially the message was, let the people who are not in their, the kind of relationship with God that we have, let them do whatever they're going to do, and our focus is going to heaven. That was very much the orientation, be in the world, but not of it. Over the past 30 years, an incredible shift has happened, that rather than have this wait until the return of Jesus, and I'm speaking very much from a Christian lens, I want to be clear about that. Rather than wait for this return of Jesus and then have the kingdom of God that God envisions for us to be here then, we're going to bring it now. And with that, we're going to have rule over, control over the political and cultural institutions. So many of us know Swaggart and now I'm forgetting people's names, Pat Robertson and several, but there has been a whole group of individuals, many of whom we do not know their names, who have really been directing a lot of what has been happening here. And so a few points I want to share with you that I think are critical to how we talk about religious exemptions and religious freedom in today's context. 4 things about the dominionist movement that I'm discussing. One is dominionists celebrate Christian nationalism, and they believe the US was founded to be a Christian nation and should be. They do not make any allowances for religious pluralism. They regard the Enlightenment, the humanist roots of American democracy, as unbiblical and counter to God's law. So when many of us talk about the religious freedom and the frame that was part of our American democratic system, dominionists who have taken root in all levels of US government really regard that as counter to God's law and are fighting against it. Third thing, dominionists promote religious supremacy. They do not respect equality with other religions, not even other versions of Christianity. And by other versions, I mean versions and expressions of Christianity that are different even from their own. And the fourth thing, they believe that the 10 Commandments should be the foundation of American law, and that if there's any value in the US Constitution, it is for it to be a vehicle for implementing the biblical principles. Some dominionists believe in capital punishment for a range of things, for someone who has an abortion, for someone who assists in someone having an abortion, et cetera, et cetera. And they base that on their particular understanding of biblical law. So the question that all of that raises for me, how do we, speaking of law and religion, as it relates to abortion and other reproductive justice issues, how do we have the conversations when there are some of us whose understanding and whose epistemological approach to what law means, to what rights mean, et cetera, vary so widely? For me, it is absolutely amazing that the frame of religious freedom that Madison and Jefferson wrote about in the 18th century, it is amazing to me that dominionists and Ted Cruz is one of them. Apologies today. I've been having so many meetings. I don't even know what planet I'm on today, so apologies. But Ted Cruz, you know the guy who I'm talking about from Texas. He and others have been taught an orientation of dominionism. And then there are other political leaders who are not of that theological orientation, but they do recognize the opportunity to seize power. And so there is this connection of those who come from a theological perspective and those who come from a political perspective, all of which is rooted in power and dominance. So how do we talk about issues of rights of all sort, including the right to have access to an abortion, the right to counsel people about their reproductive lives in ways that honor our own traditions, and the right to have varying theological beliefs regarding when life begins? Because those were the 3 things that Dr. Frank spoke about. The there is not a single approach to those. So how we talk about that is a big part of the work that RCRC is seeking to do right now. How do we understand the way language is being used by people who have this dominionist orientation? And how do we understand language being used by those who have a more egalitarian, more justice orientation? Dominionists, by and large, regard justice as a bad word. It is something of a human construction, even though the way I read the Bible, God of my understanding is very much about justice. And that starts in the earliest of the texts. And yet dominionists skip over all of the language about justice that's in the text. So having the conversation when we talk about justice, understanding that some approach that from a very humanist perspective, and therefore they disregard it. Understanding that some believe the only way for them to be in service and in right relationship with God as they understand God is for them to have dominion over the political and cultural systems of this day. That's the context in which we find ourselves right now. We are not using language in the same way. Our epistemological frames are so widely different. And so I'm sharing this contextual piece because in order to understand the debates about abortion access and the debates about abortion bans, et cetera, really requires that we recognize how it operates within this broader framework that we're in. And I know my 10 minutes is up, but we will get to more a little later, hopefully.
Great, thank you. So what I wanted to do was just give folks a snapshot of how the religious right to abortion care is being litigated currently. And right now, the Lawyering Project, which is the organization I work for, is representing abortion patients and plaintiffs in a case in Indiana federal court challenging Indiana's requirements that embryonic and fetal tissue from an abortion or miscarriage be either buried or cremated. The law requires healthcare facilities to dispose of the tissue in that manner, and it requires abortion and miscarriage patients to actually certify that they're choosing an option, quote unquote, or they can take the tissue from the facility and dispose of it in their own manner and at their own cost. When this law took effect, it was very clear immediately that it was having a significant impact on care. It was confusing patients. This is not something you expect to hear or see when you walk in to a healthcare facility for healthcare. It was shaming and stigmatizing folks. It made people feel like they were doing something wrong. And for many people, it was conflicting with their dearest, sincere religious and spiritual beliefs. And so what we heard from the ground was that this law, just as much as a law that is shutting down a clinic or banning a procedure or a medication abortion, was curtailing people's right to abortion care. And so we started talking to patients and we started talking to providers, and it became clear that we needed to challenge it. And so in addition to arguing that the laws violate a right to abortion, these plaintiffs are arguing that the laws violate the Free Exercise Clause and the Establishment Clause. And there are two patient plaintiffs that have made their religious beliefs explicit in the case. One is a woman who had a 3-month-old child when she became pregnant again. She had had debilitating nausea with her first pregnancy and did not feel like carrying her second pregnancy to term would allow her to care for her child in the way that she wanted. She's a practicing Muslim, and she believed that these laws conflict with her beliefs about when life begins, about what pregnancy and abortion and motherhood for that matter is. Another patient plaintiff, when she became pregnant, also had severe pregnancy symptoms. And it was one of the reasons why she wanted to obtain an abortion. This was exacerbated by the fact that she's a cosmetologist and on her feet the whole day. And she's a practicing Baptist. And again, she felt that these laws conflict with her understanding of when life begins, what pregnancy is, and what it means to make a loving and caregiving decision with respect to building a family. And so the free exercise claim in the case is essentially that the laws impose special disabilities on anyone that does not agree with the religious beliefs that the laws are promoting. And so again, you can see what they are saying specifically about the nature of an embryo or fetus or pregnancy or abortion. In terms of the Establishment Clause, the argument is that the state essentially is promoting specific, again, religious conceptions of fetuses, embryos, abortions, pregnancy, and again, parenthood for that matter. And it's forcing non-adherents to effectuate those beliefs, either by consenting to having their tissue cremated or buried, or taking custody of the tissue themselves, which again is not something you see in any other aspect of healthcare, other than basically pregnancy related care. And I think that there has been some surprise that these claims are a part of the case, and I kind of want to address why I think they squarely belong in the case and why, in fact, they're critical to the case. I think one, first and foremost, they are coming from the patient plaintiffs, they're coming from the clients. And I think any good lawyer knows that your chief responsibility is to your clients and to make their needs, their wishes, their harms explicit to the court, and in this case, explicit to the public. I think the second consideration in this case and other cases that may involve explicit religious rights to abortion care in the future and have in the past is that the abortion right, which on the one hand is no longer a right for many people. I think Texas is an example, but I think you can look at low-income folks across the country for whom it hasn't been a right for a very, very long time. It hasn't been a right. But on the other hand, jurisprudentially, it is. It continues to be, and I think my colleagues, which include non-lawyers and a very, very large movement, including the clients and patients, are not ready to accept defeat until defeat actually happens. And I will say that if you look at Planned Parenthood v. Casey, which obviously is a landmark decision in terms of abortion care and the 14th Amendment right to abortion, there's actually a very clear line that connects the abortion right to the conscience and to the right essentially to form your own beliefs. One of the bases for the right to abortion is the fact that as human beings, we have to have the right to form our own beliefs about what life is, when it begins, what it means, how we should live our lives. And Casey has very clear language to that effect. And so in some ways, I think the abortion right itself is rooted in what we consider the religion rights and in what we consider the rights to conscience. I think the other thing, as I think, Liz, you mentioned at the beginning of the panel, is that in many ways, the so-called religion rights have strengthened over the years and certainly strengthened, at the Supreme Court in the past, I would say 5 years. And there is a sense, again, that that set of rights is somehow mutually exclusive, opposed with and to abortion care. And I would argue that, like any positive development in the courts and in the law, the the most important consideration and the strongest fuel always comes from outside the courts. And I think one of the biggest changes that has happened parallel to the strengthening of the religious rights over the last few years has been just the incredible power, visibility, and bravery of abortion patients who should not have to, but are willing to tell their stories. And many of these stories involve a grounding in faith, whether it is the fact that their decision to obtain or pursue abortion care was rooted in their religious beliefs and what they understand, again, to be life and family and caretaking. And also in the stories of providers and counselors who, again, do that work and see that work as a ministry. And I think as that movement grows and becomes more and more visible, and I actually think that crises in places like Texas help that along, because they push more and more people to go out there. I think that we have a better shot of actually prevailing on those claims in court. I think thus far, those claims typically have not actually gone to trial. And in some ways, you know, that's obviously a loss, but it also means that the rights haven't really been litigated. Folks really haven't had a chance to put evidence on. They haven't had a chance to bring the expertise of their clients and patients and plaintiffs forward. And I think there's an incredible opportunity there, especially if the traditional right to abortion, meaning the 14th Amendment due process right, continues to get chipped away in a more formal way. So I'll just stop there, but I'd love to, you know, again, explore these topics with the panel and with the audience.
Fantastic. Thank you all so much. I think I'm going to, you know, take moderator's liberty and ask a few questions, but I would encourage folks to submit our listeners to continue to submit questions to the Q&A, and we'll start working those in as well. You know, I think I'd like to start with just a very kind of nuts and bolts question where we left off. Rupali was, you know, said these things haven't really been litigated, and I'd love just, you know, your sort of, not to look into a crystal ball, your initial take on, you know, what might these kind of claims look like? What might a challenge look like in Texas that's based on, you know, free exercise clause? Maybe also if you could work into that a little bit, what's been happening with some of the Satanic temple litigation and how that's fared. And if you see this as like a really a viable avenue for protecting abortion rights going forward.
Yeah, as I think my comments touched on, I do. And I want to credit not the work necessarily of, and not that it's not important, but not necessarily the work of the litigators who have been willing to advance the claims, although that's important too, but really, again, the work that's happening outside of the court that really helps show people that this isn't just a legal strategy. It's not, you know, it's not something that someone came up with at a meeting because, you know, the Roe is in danger. This is something that people actually live and feel and are impacted by. And it's always been there, whether or not those claims have been in these cases. And, you know, you don't have to bring every legal claim that a restriction impairs. You just have to get the restriction invalidated so that you can continue to enjoy your rights. And so again, the fact that these claims haven't been a part of cases in the past doesn't mean that they haven't always been violated or endangered. But I think that there's more of a chance, again, of them prevailing now because, one, people are willing to bring them in cases given where the 14th Amendment, given where the right to abortion under the 14th Amendment is at, or the perception around it. But again, also because people are stepping up and making the connection and refusing to accept this false dichotomy between abortion access, abortion care, abortion provision, and faith and religion and spirituality. That is a false dichotomy, and people, many people are refusing to accept it and being very public about it. And I think once that saturates the popular culture, once, you know, the court can't kind of look away from that and has to see that and reckon with it. And once the media also integrates it into its reporting, I feel like you're in a different place, and that those claims can go a lot farther. And so to me, it's less a matter of, suddenly the legal standard is different. Employment Division v. Smith has been overruled or anything like that. I think it's really the work that's happening outside of the courts. And I think you had asked about the Satanic Temple cases. My understanding is that there have been a series of cases since 2015. There's a pending challenge in Texas. There has been a lot of work basically in Missouri and in the 8th Circuit. And they have largely challenged very common abortion restrictions like so-called informed consent provisions, ultrasound requirements, things that are medically unnecessary but tend to inhibit abortion access, especially for the most vulnerable folks, and again, shame and stigmatize people. And generally, the court's reception has been that these laws are not motivated by religion. They may align with certain religious beliefs about abortion or about pregnancy, but they're not actually promoting or rooted in religion. And again, I think the change that could and should, and I think will happen, is that courts will have to understand that when you promote a world in which unnecessary abortion restrictions are allowed to persist, you are placing special disabilities on certain folks of faith. You are impinging their faith. It is a targeted burden that actually does and should survive the Smith frame, where you only get rational basis review if you're dealing with a neutral and generally applicable regulation, which is wonky and we can talk about. So I'll just stop there. I didn't want to take up any more time, but that's the change I see happening and I'm optimistic about.
Great, thanks so much. So I think that you emphasized about how just because it hasn't been litigated, it doesn't mean this hasn't been an issue. And also how important the kind of extra legal strategies are. So I think what I'd like to do is turn to Reverend Jackson and say, RCRC has been around doing your work for a really long time. And I think it'd be really, I'd love for you to speak to how your placement as a faith organization places you in a different, how the work that you do is somewhat unique as opposed to other abortion advocacy organizations, and how your background as a faith leader and your placement as a faith organization changes the way that you have those conversations in the context, as you were saying, of this very dominionist attitude towards abortion, of there is one way to think about it, there is one religious view about it. Can you kind of talk a little bit about your approach and how you engage those conversations about faith and abortion?
Yes, one of the things that is very critical is the intersectional approach that we are bringing to our work. And I think so much of what we have seen in 2021 alone, where voting rights and abortion rights have simultaneously been the points of attack in this year, those 2 points of attack really signal to how important intersectionality is. Because this dominionist orientation that I was talking about earlier really speaks to how about 15% of the society, 15% are in this place of wanting to control how the other 85% operate. And during this time when there's been this shift politically and religiously, people with the dominionist orientation have been moving into judicial positions, state legislative positions, school board positions, on and on and on, and really directing and controlling a lot of how we have been functioning lately. So what Rupali was talking about, the extra legal activity, I think is really important for the 85% of us across religious traditions, those who are not affiliated to really band together and call out what kind of society do we want this to be. And issues such as compassion and justice have really not been a part of the orientation of the 15%, and in its own way, moving toward an apartheid type system where a very small minority is ruling and controlling how the majority operate. And I think so many of us have been asleep to those realities. So part of what RCRC has been seeking to do in a way that's different from its earlier iteration, and that is to help people see what some of the behind the scenes activities are. I think many of us have believed that justice is something all people of goodwill and people of faith, et cetera, want. And you spoke earlier about the dichotomies. The dichotomy is not abortion versus religion. The dichotomy really is justice versus control. And we need to be very clear about that and hopefully help more people understand, because the other things really have been false dichotomies. You know, as a person of faith, most spaces I go in talking about abortion, initially they're a bit tenuous in how they relate with me because they have bought into the narrative that religious people are anti-abortion. And that's why I really appreciate the work that Dr. Frank has been doing, because he keeps lifting up. No, folks, that's not the case at all. Here's the reality historically, and here's the reality today. But people have really bought into a dichotomy that's not the real issue. And because they've bought into that, a whole series of other things have been happening in the shadows that I think many people have been missing out on.
So I wanted to ask Dr. Frank, so you said that and I think this kind of goes along with the theme of what's happening just outside of the courtroom. You know, as you said, that there isn't necessarily clear lessons to be gleaned from the litigation that happened pre-Roe with the Clergy Consultation Service. So then, you know, what lessons can we take from the Clergy Consultation Service? You know, what do you think, you know, were the most effective strategies, and perhaps what were the least effective strategies as well? Where can all of us learn and grow from what happened with the service?
Sure. I'll try to keep the answer brief because those lessons are the book in essence. But I think the first thing I would flag is that this was a group that was about 85% male, predominantly white, but at a time when only 1% of all clergy was female, 15% of that group was. And so they created spaces for female leadership. The premise of the group was built-in obsolescence. They sort of viewed themselves as creating a pathway for people who became pregnant to seize control, what they called dominion over their own bodies, and tried to create legal and social opportunities. So they're a model of allyship. How do we use our religious authority, our religious power to create space for others? And so one of the reasons I think that they're uncomfortable in the histories that we tell is that they are a misfit in many ways. White male clergy trying to create space for others to actualize their reproductive choices. I think one of the other lessons that we can learn from them is that they were a robust grassroots organization that had deep roots in other struggles, anti-war, civil rights. They were intersectional from the outset and tried to continue and actualize that. And so when they were given opportunities to continue in institutional forms, they ceded those to other groups, Planned Parenthood nationally, Choice in places like Pennsylvania, and they tried to lend their authority and voices elsewhere. And so I think these are some of the lessons. But I think one of the biggest things that they continued to argue was that freedom of religion is freedom from religion, to create sort of judicial and cultural space for free exercise of religion meant to create and I'm paraphrasing them, a legal space for others to exercise their conscience. And so they used words like choice. And what they meant by that was, if you believe that abortion was a moral wrong, then you ought not have one, but don't exercise those views upon others, don't impose upon others. And so I think these are ongoing lessons to be learned from them. I'm going to stop there to continue the conversation.
So I'm gonna bring it back to Rupali. You know, we've been touching about this expansion of religious rights, and particularly at the Supreme Court level, the COVID cases like Hobby Lobby, and I wanted to get your perspective as obviously someone who litigates a lot and thinks deeply about abortion rights. Do you see a danger in either litigating or more broadly, just framing this as a religious right when we've seen the expansion of religious exemptions used in very harmful ways, and where, maybe we could eke out a tiny right to, abortion, but if you're in a state, let's say, that is very conservative, expanding this right to religious exemptions could really have an overall negative impact. Do you see any risk there, and sort of what is your thinking about that tension?
Yeah, I appreciate that question. I mean, I think there is a couple of responses to that. One is practical. I do think that again, my work is and should be promoting the interests of my clients, and to some extent, when there is something happening, whether that's the strengthening of a right or the building of a social movement that could broaden access to something like abortion care, which obviously has a profound impact on people's lives, and that train is already in motion. It pains me not to try to leverage that for my clients who could benefit from it. I don't think that artificially excluding people who sincerely see abortion care, whether it's facilitating it or accessing it or providing it as a form of ministry or as a form of spirituality, and kind of exempting them from that is in their interest, or again, in the interest of justice. And so I like to be open at least to those approaches. I think the other thing that's going on is that I agree that, there are situations, especially when you're talking about exemptions, which is some of the ways in which, fortunately or unfortunately, it's definitely a point of debate, the religion rights have really grown. This idea that exemptions need to be granted if there are any secular exemptions, essentially, which I don't think is historically accurate in terms of the law, but is I think the direction in which the Supreme Court is moving, for sure. And I think the reason why that gives people pause, well, probably is one, because they don't think those exemptions will actually be granted to people who are either providing or accessing or facilitating abortion care. But even if they were, I think the danger is sort of accepting that as enough, when really the religion rights could and need to be leveraged to help design a fuller system of healthcare, right? So abortion care should never happen in this silo. It's not that this patient should be able to get an abortion. Of course they should be. But the issue is, that we don't have a healthcare system, obviously, that fully allows people to build their families, or really, a society in which that fully allows people to build their families. And what I hear my co-panelists saying is that really, this is a matter of justice. And so these rights should really be used to kind of work towards a different infrastructure, and not just, kind of leveraged in terms of exemptions. And I don't think it's mutually exclusive. I think you could do both. But I certainly am open to it. And I don't see, my client's not benefiting from jurisprudence that's jurisprudence regardless of whether they participated in it or not, helpful.
I'm gonna work in an audience question, and please continue to submit them. And I think this one probably makes the most sense for Reverend Jackson. To summarize, James asked essentially that to shift public discourse, we're going to need, a robust conversation, about an alternative understanding, a religious understanding of abortion, but that many of the denominations that we've been mentioning in the discussion, ELCA, the Lutherans, Presbyterian Church of USA, Reformed Judaism, have seen membership declines. Weak congregational engagement over the past decades. So given that, how do we kind of reignite the left to be more vocal in the public square?
I really appreciate that important question. So one of the things that RCRC is doing is relaunching a program that we operated back in the 1990s, early 2000s, and that is called Spiritual Youth for Reproductive Freedom, acronym SURF. It is a program in which we galvanize young people, college campuses and elsewhere. About 20 to 25% of the US population right now consider themselves not affiliated with any religious tradition. And for years, in the early days of RCRC, we worked very closely with religious denominations. Those denominations over these past 30 years, many of them have undergone incredible shifts where within the denominations that have identified themselves as progressive, there has been this growing presence of those who are much more conservative. So conservative about sexuality, about reproduction, et cetera, et cetera. And they have, in a large extent, put a chokehold on some of the denominations that had worked very closely with RCRC back in its founding. So we have been diversifying how we reach out to people who identify not only as people of faith, but people who are spiritual in their orientation. And that may look a broad range of ways. And I think this way that we're approaching spirituality, so even though our name is Religious Coalition, it is religion and. It is religion and spirituality. And those who approach life and who approach their understanding of what it is to live in a society and to be a participant in a society, they approach it guided by spiritual principles. So that's a major thrust that we're engaged in now, because there's a whole swath of people who have not had an opportunity to be involved in the work if it's only focused on religious denominations. So we're doing both so that we can reach a cross-section of people who share in a spiritual principle of compassion, who share in a spiritual principle of justice, and who share in a spiritual principle of mutual responsibility. One need not be religious to be guided by those kinds of principles, but one does need to be strategic. If those are the principles that guide a person, then we're also greatly encouraging people to participate in the range of public service that is available, because that's where we get to make some incredible impact. And perhaps you've heard just yesterday, I learned of it anyway, that a woman on a school board in Florida was being harassed and politically attacked because she believes in mask wearing to keep children safe in schools. But that's the environment we're in now, where there's this unleashing of incivility. There's this unleashing of, I have the right to dominate and have power and control over other people's lives. And in order to shift that as a cultural narrative, it really requires us to engage in conversations about what kind of spiritual principles do we want to help guide us as a society, and to make sure we get people who are positioned in various decision-making spaces to help guide us as a society in those ways.
A question for Dr. Frank. I'm going to kind of split Sandy's question up a little bit. She wanted to know if there have been iterations of Dominionism throughout history. Essentially, how did we get here? How did we get from the Clergy Consultation Service on abortion to the landscape that Reverend Jackson was just describing, where kind of the entire conversation has just been sucked up by kind of people with a very narrow framing of the issue?
Sure. So what we're asking about is sort of the post-Roe religious landscape and what happens after we see a sort of robust religious liberal coalition arguing for abortion rights. And so this is a long and complex history, but what we're seeing from the late 60s throughout the CCS's sort of tenure is both an intra and interreligious debate over abortion that gets in some ways battled out in a number of jurisdictions, from court cases to a referendum in Michigan in 1972, to as well a number of legislative hearings. And what we see after that particular moment, sort of circa 72, is that the leaders of the CCS look around and they say to themselves, well, really, the Catholics are the one who oppose abortions. Mainline Protestants are all in agreement. All Protestants are in agreement that abortion is a good. And they are looking past the sort of evangelical freight train that is sort of rolling towards them through the Nixon administration, going forward through Ford, that was an unintentional rhyme, as well as Reagan. And so what we see, starting with Nixon and moving elsewhere, is that there is a right-wing coalition being built from Catholics, Mormons, evangelicals, Orthodox Jews, who are all organizing around sexual issues, abortion, gay rights, and so forth. And they're using this as a wedge to move people away from broader economic concerns and structural concerns, to roll back other issues such as racial justice and inclusivity. And so this is a long-term project. It's not one that was short-term. And so what Reverend Jackson is calling Dominionism, we might just broadly more call a growth of a religious right that tries to, in their words, they're willing to make coalitions, but they want to Christianize America, and they want to use sexuality as a key lever to turn many gears. And so we see this earlier battles in trying to strip away abortion access through things like Medicare and Medicaid. They'll do it on a state level. Then we see it in the Hyde Amendment. And they realize that it turns out voters to the polls, that it is a really useful fundraising issue. And what we also see, and there's scholars like Neil J. Young and Jennifer Holland and others who have detailed, and Mary Ziegler, of course, who've detailed the sort of post-Roe trajectory of the anti-abortion movement and the religious right, is that they've rested on a number of assertions. One has been erasing the people who are actually pregnant, their wants, their wishes, their needs. The second has been to sort of conflate abortion with the Holocaust, abortion with murder, abortion with genocide, in order to build a broad-based coalition and to castigate abortion as a moral evil. And they've won politicians over to their camp by being very active in primaries and so forth. So there's been a long and ongoing political history. Now, at the same time, religious left has been robust, has been active, but they were in many cases content to sort of see the law as the primary battleground for this, without maintaining a strong grassroots pro-choice movement, even as, and we can't fault them for this, there were other fires to put out. Whether the sort of impetus was sort of anti-nuke activism, to environmental activism, to whatever the issue of the day is, liberal religious clergy and laity, as their denominations have shrunk in terms of who's in the pews, have been spread thin, even as there has been millions upon millions of dollars funneled into the anti-abortion movement and lots of seed money for it. And so the playing field hasn't been level, even as politicians have tried to capitalize upon anti-abortion anger, paying lip service to it or believing it until there was no other place for them to go. I'll tell sort of an anecdote. I was in Michigan doing research on an earlier project about the history of anti-abortion activism in that state. I was looking in the private archives of one of the major leaders in Michigan, Right to Life. It was primary season while I was there. And so as I'm sitting there in this guy's basement, which was like frozen in time from 1973, 1974, we're talking about shag carpets and all sorts of posters that were timepieces. People walking through the front door were Tea Party Republicans versus more center Republicans, and all of them were trying to court his vote, whether they were sincere or not. And he admitted, he's like, I don't know if these guys are sincere. The point was they were going to pay lip service to it. And that scene was replicated across the country for decades, which is to say, anti-abortion activists could churn out voters. And so politicians came a courting. So that's in part the story that we're there. Whereas I think that the left has been fragmented for a number of reasons. There's been many circular firing squads over the years, and there's been declining people in the pews. And so groups like Dr. Jackson's and others, as well as on the local level, continue to fight the good fight and continue to assert a religiously pluralistic view that holds that religious minorities and those who are not religious at all still have a moral right to choose. So I'm gonna pause at that point.
So picking up on the people of no religion, we want to make sure we're not leaving that out of the conversation. We've had a couple questions, and I had my own kind of thoughts, which is how are we acknowledging them in this conversation? Are they benefiting from any of these kind of either legal claims or these extra legal kind of activism? How does this not become just an argument of different religious people arguing about what religion means? And so I guess I'll start with Rupali, if you could talk a little bit about how you feel this kind of as a nuts and bolts legal strategy or other kind of external strategies are how they can make sure they're inclusive of and benefit secular folks as well.
Yeah, I think two thoughts come to mind. I think one is that I do think that, at least jurisprudentially, religion has a special place. And so there is something, and just again, speaking strictly in legal terms, that can be different and useful if one is operating in a religious frame. Again, if you have a client or a patient or a provider who's coming from that perspective and identifies in that way. I don't think that means that the law, if these claims start to take off and if this type of litigating is to become stronger, can't benefit folks who don't identify with that frame, but nonetheless belong in this conversation about justice. And I think one of the things I talked less about was maybe the establishment side of things versus the free exercise part of it. I think the benefit to bringing establishment clause claims can be that you are, one, putting the focus on the state or on the population or group of folks that is trying to do harm, calling it out as pretext, calling it out as what it is, which is a specific ideology, a minority ideology that you're trying to impose on other people. And so to that extent, it matters a little less how exactly and what exactly the individuals who are being harmed identify with. And the focus is more on the fact that, again, a specific group or there's a specific set of beliefs that are trying to be imposed on others, or really, options that are trying to be taken away from folks. And so I think that side of, like, I've been talking about the religion rights, I think that side of it is super important too. And I do think more and more and more, it's important to call out what's happening as a specific ideology. And, you know, in our cases, what states argue is that these restrictions are being implemented or enacted on the basis of health and safety, which could not be farther from the truth. They almost always severely harm health and safety. And so I think, you know, there has been a lot of attention on making that argument about pretext and improper purpose within the undue burden frame and within the traditional abortion right. But this is just another way to look at it. And I think just as true to what's actually going on and what's actually motivating legislatures. So I think that can be one place where it's less important how people identify and more important how their rights are being impinged and how they're being hurt as individuals.
Just a quick follow up from that specifically, and then I want to ask Dr. Jackson to talk a little bit about the kind of incorporating secular communities, but just a quick follow up. We had a question from Jax, who was involved in the Satanic Temple litigation in Missouri, who says, you know, when they were bringing that case, they just heard over and over from state legislators and legal representatives that, you know, oh, these restrictions have absolutely nothing to do with, you know, religious or philosophical beliefs. This is, you know, there's just this, they happen to coincide, but that's not where they come from. And she asked, you know, is this even a tenable argument going forward? Is there going to be any budge in the court system?
Yeah, I mean, I think it's a bit of a catch-22 in that if you're not willing, and certainly the person who asked this question is, but if a greater number of people aren't willing to make these arguments with conviction and with the kind of sincerity that they deserve, again, because they are actually reflecting what's going on with clients and patients and providers, then yes, the courts aren't going to budge. On the other side, right now, we're seeing arguments that were made in dissent for years and dismissed as silly become precedent. And so you have to do that work and lay that groundwork and unfortunately lose a lot if you want to see that sort of change. And again, I mean, I am willing to try whatever works and what actually reflects my clients' experiences. And so I'm all for like continuing the work. And I do think part of what may be going on is that when courts were a little more, I think just in general, like we've been talking a lot about the abortion right being impaired, but there's also been just a change in the judiciary and in courts, arguably. And when courts were, I think in general, I would say just more hospitable to individual rights and minority rights, there was a sense that it is strategically helpful perhaps not to lean on pretext and call out state legislatures for what they're doing. And I just think that is no longer appropriate or tenable. And I think we should point to the elephant in the room and again, call out these laws as the imposition of a very specific ideology rooted in misogyny and all sorts of other oppressions, including racism. And so, and I think again, that can fold into an establishment clause line of argumentation.
Wonderful. So I want to open up for Dr. Jackson to respond about including secular communities. The other thing I just want to, I mean, I'm sure you could probably school us all for hours on this, but we had a couple questions about like just a little taste of pro-choice theology. If you could give us a little bit of your biblical understanding of where these ideas come from, I think folks would really appreciate that as well.
Okay. As I mentioned before, about 25% of the US population identifies as not affiliated with a religion. And many of those individuals consider themselves people who are guided by spiritual principles. And even those who don't identify in that way, it is the case that, as Dr. Frank said earlier, it is not only about freedom of religion, but also freedom from religion. And that is something that has to be moved forward in all of the conversation. I talked earlier about a spiritual principle of mutual accountability and mutual responsibility. We have moved away from that. Some of us have moved very much away from that principle for how we live in society. And I think that's something that needs to be lifted up more. I keep asking folks, so what kind of society do you want us to be? And what kind of society do you want to live in? What kind of society are you willing to help work for? As Rupali has said a few times about stepping up, we need more people to step up and call it what it is, and not presume that because someone is in a particular position that they intend goodwill for the broader society. We've got to stop assuming that, because it often is not the case. There's something psychologist Pierre Bourdieu called misrecognition. And we have so much of that in US culture, where things are framed in a particular way and people are led to believe it's this when it's really that. You know, it's the bait and switch. It's all of those kinds of things that we have in our politics, and we have it in our theology. And one of the things I urge people to call out is the pattern we have in US culture and other cultures for folks to want power and control, and then they theologize it. It really doesn't have anything to do with their theological beliefs, but they put a theological label on it to give it a certain credibility. And we have a lot of that happening now. And so when it comes to abortion, so much of that has absolutely nothing, and in my opinion, has absolutely nothing to do with theology, but it has been theologized. And much of it in the turn of the last century, President Wilson said to white women in the aftermath of slavery, so here now is this whole body of former Black slaves who are having children, and they're moving toward this right to vote. And so two things happened. He said, white women, you have a responsibility to your race to have babies, because many more women were going to college, and it went from 5 to 6 children per family to about 2 to 3. And he said, our race can't survive like this. But he also, in the midst of that, helped move forward for white women to have the right to vote. Because part of what was a real source of anger for white women was that Black men would get to, former Black slaves would get to vote, and they didn't have that right. So there are a lot of social issues, a lot of emotional issues going on, power and control issues that get theologized, and we have to call those things out as they are. There is so much of racism running in and through a lot of what's happening. And I spoke earlier about voting rights and abortion rights. So much of that racism running through that in this process of the browning of the US, and a lot of folks don't want that, and then they theologize particular positions that they have, and we got to call it out for what it is. Call it out for the racism, call it out for the classism, the xenophobia, et cetera, and say, show me where God was really calling you to. And that's why people in positions like mine who are ordained, we have to speak out and be in conversation with historians and with lawyers and on and on. So collectively, we can call things out for what they really are.
Well, this has been incredibly rich conversation. There are 10 questions on my list we didn't get to, but I think I want to just give you all an opportunity to just close out with any sort of final thoughts you have. And why don't we just go in the same order as we started? So Dr. Frank, if you'll just kind of leave us with your last reflections. Where are we? Where do we go from here?
Sure. Thank you so much for this opportunity to speak with you all. This has been a real pleasure. I just want to end with one thought, and it is about a theology of choice and its history, which is that when the CCS offered pastoral counseling, when they invited people to come speak with them, they operated from one principle, which we often now recognize as secular, which is that choice matters, options matter, that having a choice is a theological principle. And so anyone who came into their offices, into their synagogues, into their churches, they asked them, what is it you want to do with your body and your future? For them, this was a profoundly moral and theological question, what we now just simply call choice, and what the religious right has deemed as secular, as humanist, as feminist, all in pejorative terms. And so when we remember that the history of reproductive choice is a moral history, is a theological history that creates space for everyone to choose, we reclaim something of that conversation. So I'm going to leave on that note.
Well, thank you. My closing words are the theology of human flourishing. It is so important that we use theological frames and secular frames that are centered in individuals flourishing in their own lives. In order for people to flourish, they need to be able to have bodily autonomy. They need to have social supports as it relates to childcare and health care and living wages, affordable housing, on and on and on. It is about human flourishing, and that enables individuals to have a greater quality of life. And it also enables us to be more of the kind of society that flourishes. And the last thing I want to say is really, I saw a question about medical ethics. It is important as we call out the theologizing of power and control and dominion that has been sweeping our nation. We need to point out that it has brought an incredible frustration to the medical community because they too are constrained in doing the work that they have committed to do that also is rooted in human flourishing. And that is something that guides so much of my life, is helping people to flourish in the ways that are good and right and whole for them.
I can't say what you just said any more beautifully, but I will say that the law is definitely an imperfect, blunt, eternally frustrating instrument that I have chosen to work with nonetheless. But that said, it is what we have. It's one of the tools we have, and I do think that it can be used to hold people accountable for doing exactly the opposite of what Reverend Dr. Jackson just said. And so I urge people, I know there is an incredible amount of demoralization and sadness and fear just around the abortion right in particular, but I just urge people to be a little brave and just kind of be willing to make these arguments, hold people accountable, call out what is happening. We have nothing to lose in doing it. And the courts can change, times can change, and we won't be able to take advantage of this rich history and the rich work folks are doing if we don't set ourselves up for it. And so just urge people to be a little brave and to be a little less cynical, which I myself am guilty of sometimes.
Those are perfect notes to end on from all our panelists. Thank you so much. We really appreciate your time and your wisdom. And in half an hour, if you want to hear more about faith and abortion, join the amazing folks over at Auburn on their webinar. So thank you again. This will be up on our YouTube channel if you want to share it with anyone else. And have a wonderful evening.